Good morning, good afternoon, good evening, everyone. It's a great pleasure for me to moderate this panel, which is indeed addressing a topical issue in competition law. Namely, our brilliant speakers will try to discuss what are the main challenges raised by the digital evolution, the digital transformation, to the predictability in the application of competition law with different perspective under different lenses. So without further ado, I would like to give the floor first to Vinícius Klein, and with this, I would take also the opportunity to thank IBCI for this invitation. I'm a proud member of the expert group of IBCI, and I truly believe that is making a great job to increase the food for thought and the debate we are having as competition law scholars. So many thanks for this excellent opportunity for a discussion. So I think Vinícius Klein does not need an introduction. He's a professor at the Federal University of Paraná, and she is, of course, one of the director of IBCI, and he will give us an overview, a very interesting perspective on the issue we will address today. So Vinícius, please, the floor is yours.
Thanks, Laura. Thanks very much for the introduction. And I'm very honored and pleased to speak here. This opportunity with Inês, that's a fantastic scholar, and her work got my attention some months ago, and it's very good. And to talk with Laura, that is an expert and has a very important scholarship. I'm going to just say Marie Curie, because in the middle there is a hard name to pronounce it. A scholarship about a topic that connects with this discussion, but it's a very good opportunity to discuss this point. I start to share my screen. So the idea is to discuss legal predicability and competition law in digital market. First point, I think it's this idea, this sentiment that competition law enforcement is a little weak regarding the realities of big tech and digital markets, and it needs some kind of boost, some kind of help, or some new tools to do it. Because until now, there is a perception that the job of competition enforcement in digital markets is not so good or not so effective, and a lot of mergers and conducts and practices like self-favoring and other practices are beyond the scope of enforcement and must be more attacked by competition authorities. But this sentiment of going against big techs, it's a good thing in point of view of looking again to the effectiveness of competition law, because it was a topic that was not so well discussed in the recent years before big techs, and was like a very consensus and calm debate in some points, and needed this revival. But the risk, and this is not new because you always have this risk when you try to enforce more laws and more rules, is to boost the effectiveness, boost the enforcement of competition law, but at the cost of losing important level of legal predicability or legal security, or through fighting or something like that. And the idea, I think, of this panel in a whole, and my presentation, is to try to see better this trade-off and to discuss it more openly. So the lack, what makes more critical this trade-off is the lack of one source of objectivity and a perception, at least. Maybe you can discuss if economic concepts and economic theory is really a source of certainty and objectivity in competition enforcement. But the traditional way of doing enforcement of competition law in the consumer welfare standard has a lot of has the idea that the imposition by economic concepts and the non-economic concepts being treated as some kind of noise makes or assures us that this imposition is objective, has a lot of predictability, and the guidelines, the soft laws that competitions authority use are appointing that aim, because we can see the methodology, the kind of economic theory that's going to be being used in the new case, and this makes more predictability, produces more predictability, more transparency, and more objectivity, at least in the majority of the opinions. But why legal predictability is important? You can have like a discussion in a more traditional law approach about democracy and things like that, but in a more law and economics approach that I think is more close to our discussion, legal predictability is important in the way, especially because if you want to coordinate behavior, the people must know what to expect and have their expectations correct, assess it as legal or illegal, and if this is not present, the coordination aspect of law, and that's important aspect in the approach of law and economics, it's lost because the capacity of coordination is lost. Also, if you want to say this conduct is not legal to companies and have this deterrence effect, the company must know before that this conduct is illegal. And you have some conducts like price discrimination. It's a longer history of being legal or illegal, and a lot of times price discrimination is legal, for instance. This idea that competition law uses a lot of economic concepts and a lot of economic reasoning can be, I think, demonstrated in a simple thought. Like you have a lot of different countries with different kinds of and patterns of reasoning, of giving reasons in their decisions. But when it comes to competition law, and even when we compare judicial decisions and administrative decisions, because each country has a different institutional design in enforcement of competition law, they converge to the same concepts and the same methodology and the same patterns of reasoning, and that comes not so a little bit from the law, but a lot from economic theory, and the use of the same economic theory that's expressed in guidelines and the same methodological approach to competition law enforcement. This scenario has been the major scenario since the Chicago School Consumer Welfare, but not just from Chicago School, because in the Harvard School, in the first years of competition law, economic theory was there also. I think what is more typical of Chicago School, of the Chicago School approach, is the hostility against no economic arguments, not the acceptance of economic arguments. Because this is common in a lot of approach to competition law. In competition in digital markets, this source of objectivity that comes, at least in perception of a lot of authors, from economic concepts, it's still valid. It keeps functioning or not? This is one question, and one important question, I think, because the same concepts cannot be used in digital markets. And here, due to the time, and it's not my idea to discuss specific concepts of digital markets, but the traditional concepts, and price is the most obvious one that's used as an important tool for competition law has not the same effect of producing this convergence methodological approach in economic theory used in competition law enforcement. And if that's the case, you have a lost, if you do nothing, if you just doesn't change your way of your guidelines, your laws, and you don't do nothing, you already are losing some kind of legal predicability, because the one part of the source of objectivity that comes from economic concepts is not there anymore, because the traditional concepts that are already consolidated in the decisions, they don't solve our problems in digital market. And I think when we criticize consumer welfare standard in the context of digital markets, you have to think a little about two different claims against consumer welfare standard. First is this idea that I think is not just in the consumer welfare standard. It's an idea that it's before that economic arguments are the important or the most important part of competition law enforcement, and they produce a kind of objectivity and are a source of some kind of legal certainty. Another thing is to say that the only way, the only objective is consumer welfare maximization. I think that there are two different claims. Both are from the Chicago School and consumer welfare standard. They embrace both claims, but they are different claims. And of course, you can have just one. I can try to say, like, I would like to change the objective of competition law enforcement. It's not just consumer welfare standard, it's innovation, it's potential competition, it's the process of contestability, or another thing. And when I change this, they can a room for non-economic arguments as important as the economic arguments, or so relevant as the economic arguments. This is a possibility. The other possibility is a little harder, because if consumer welfare standard is something that's very economical concept, right? It comes from accidents in a Marshallian point of view, but you can try to focus not so much on hardcore welfare economics and try to do something different. But here, if you keep this claim, the possibility of embracing more non-economic arguments is not so great. And I think, and this is one of the main points I want to debate, why this first claim is so harder to lose and to be against it. Because if you talk with some Brandeisans or some critics of consumer welfare standard, they're going to say you're going to change the object, but you're going to try to keep the rationality of competition law in economic terms, in economic foundations. And like economic foundation must be there. And they say that if you lose these economic foundations, you're going to have a more juridical approach with different interpretations, and this is going to produce loss in objectivity, in legal certainty. Of course, this is some. If you want to keep these concepts, you could try to use metaphors like when you say data is price, what we're trying to do, to keep the traditional economic concepts and economic reasoning, maybe in the sake of objectivity. If you try to use new concepts, you can try to use these new concepts to keep the objective of consumer welfare, but use and keep economic claims, economic arguments as the source of objectivity and certainty, but different concepts. Or you could say, it's not true that there is a monopoly of objectivity coming from economic theory, and we can have objectivity from legal concepts, from computer science concepts, for another concept, another room of knowledge. I'm not going to discuss the DMA because Professor Inês is going to present the DMA. can have a different approach, like Professor Laura Zoboli making speak after, change administrative procedures like regulatory sandboxes, or different procedures that make more easy to have effectiveness in the competition enforcement, but with the same standard of proof, or changing standard or standards of proof, or who has to make the proof, with ex-ante or ex-post discussions. But all these solutions, they must, in my point of view, make this balance between producing legal certainty, if not from computer, for another source, and or you can discuss that there is no real objective coming from economic theory, and effectiveness. You cannot just look for one side of this trade-off. And for instance, there is a very important, I think, a very good article from Professor Magali Eben, that discusses Google and says about the decision made an conduct that was not illegal before the case as illegal per se. And this is hard to see if this is something that's going to produce a loss in legal certainty, legal predicability. Of course, if you have a new case and have like I think Professor Inês is going to discuss that, and you cannot just change your guidelines every just now because you have a digital market. You have to discuss and try to consolidate a new approach. But if you just do these cases in different ways and just doesn't change your guidelines and doesn't communicate the methodology you are going to use to assess this different reality of digital markets, you're going to have a loss in legal certainty and legal objectivity. So, trying to be on time to listen to Professor Inês and Professor Laura, there is a choice between effective legal predicability and legal certainty. And all these choices of having a per se, new per se prohibitions, change the procedures, or change the standard of proof, or even change the law, or keep doing the same thing, but having more time to consolidate the theory and the foundations, maybe in economics or in computer science, are possible choices that must be assessed with this trade-off in mind. And just finishing, like I think in the case of Brazil and some other jurisdictions, there is the question that the consolidation of economic concepts or economic foundations for competition law usually is made in Europe or in North America, discussions between like this international law and blind economics reviews and competition reviews, and it's possible, but it's harder to make if you don't have the tools to have a per se prohibition, and you must assess harm, competition harm or economic harm, and you don't have the tools. You have to develop these tools in a developing country jurisdictions. Maybe the path is a little harder. It can be a good path, can be a path that makes another option, another approach to competition law enforcement, but I think can be a harder one. And maybe that's a possible scenario if Europe uses this the DMA tools, and in Brazil we don't, and maybe one day the United States has some of the legal propositions that are in the Congress approve it. Maybe we're going to have a different reality in some countries, and this is going to be interesting to see, but maybe harder to enforce competition law in developing countries. Thank you very much, Laura.
Many thanks, Vinícius, for this excellent presentation that I think gave us the perfect set for a discussion, because indeed you pointed very well, or the balancing act and the trade-off we need to take care of. And of course, you also mentioned what is my research under the Marie Curie, which is indeed trying to set up a regulatory sandbox for a specific scenario, but I will not take any time right now. Maybe later we will have the excuse to discuss it further. So right now I want to give the floor to Inês Neves. Inês is a guest lecturer at the Faculty of Law of the University of Porto. At the same time, she's a researcher at the Center for Legal and Economic Research, and she's also working as a lawyer. Under this perspective, she will enter into she will try to discuss the issue, the general issue of this panel, focusing with a very detailed and a prepared presentation concerning the DMA, which indeed represent a perfect case study. So Inês, the floor is yours.
Thank you, Laura. I think you are all hearing me. Good afternoon. I wish to begin by expressing my warm thanks to Vinícius and all the organizing team for the warm invitation to have me here today. And I would also like to compliment Laura as well as the audience that are joining us at distance. I will now share my screen to see a brief presentation that has just some topics in this regard. So in recent times, the digital markets behavior of large digital platforms have emerged as a clear enforcement trend, especially in the European Union. The idea of a new fit for the digital age and need to ensure respect for European values by these large undertakings has led to a legislation that is considered by many a reflection of an avant-garde position of the European Union in this respect. Just in time for our conversation, the Digital Markets Act, or briefly DMA, was published last week, more precisely on 12 October, in the official journal of the European Union, and it will enter into force in November and shall apply, with some exceptions, from 2 May 2023. If we look at its recital 7, we see that the purpose of this regulation is to contribute to the proper functioning of the internal market by laying down rules to ensure contestability and fairness for the markets in the digital sector in general, for business users, for end users of core platform services provided by gatekeepers. In sum, it aims to ensure contestable and fair digital markets through some sort of ex-ante regulation and a system of alleged self-executing obligations. These obligations are targeted at digital players with significant scale and reach within the European Union, the so-called gatekeepers, that provide core platform services and that, after designation as such, are to be subject to a set of harmonized legal rules and obligations concerning practices that are considered as undermining contestability and being unfair, or both. Unlike what one might think or thought, however, and cannot change, this is not an isolated attempt to regulate digital markets. On the contrary, as the regulation itself acknowledges, a number of national regulatory solutions have already been adopted or proposed to address unfair practice, to deal with the problem of contestability in digital services, or at least with regard to some of them. And it was such regulatory fragmentation, which is cause of higher compliance costs by companies and obstacles to the freedom to provide services, that was also at the heart of this regulation, and is also one of its aims to achieve some harmonization in this regard, and as a result to achieve some legal certainty as well for companies. However, while this is true, and while confined to the behavior of gatekeepers that have a significant impact on the internal markets. The DMA has a special status since it is considered by many as one of the important pieces of legislation in recent times. Not to speak of those who trust that it will decisively influence the future regulation of digital markets at a global level, as well as to change business models and the way big tech trade their products and provide their service. In view of this, we will use the DMA as some kind of lab, providing us with a great opportunity to reach important conclusions and above all to learn from its strength, of course, but also to learn from its weakness, the application of general principles of law in the context of digital markets. In particular, our view is that any attempt to regulate the behavior of these providers of core platform services, as difficult or even impossible as it be, must ensure respect for fundamental rights, such as the freedom of enterprise, as well as for the rule of law and its sub-principles. And since any normative approach must be compliant with these general principles of law, we must avoid adopting a presumption in that these providers, these gatekeepers, are necessarily the bad guys against whom everything is possible and legitimate. Quite the contrary. Economic power has never been an argument for the correspondence to the adoption of arbitrary rules. I mean, those solutions that provide for a limitation or for a restriction on the freedom to conduct a business, the freedom of enterprise, including the freedom to design a business model, to make choices between different alternatives. But I was saying, a solution that provides for such limitation without a specific colliding fundamental right or public interest that calls for that solution, or at least that calls for that solution in such a restrictive or burdensome fashion. Of course, ensuring contestability and fairness in digital markets is, of course, a legitimate aim and may, of course, legitimate or justify the restriction in the freedom to conduct a business. And it may call, as Vinícius said, for some flexibility in the regime and in the normative acts we are thinking of. However, the identification of a legitimate aim is only a first step, and we must ensure, besides that identification, the aim we must ensure or we want to achieve, we must ensure, as I was saying, respect for the rule of law and its sub-principles, in particular, and as the theme of this conversation, legal predictability or certainty. As to the DMA, of course, legal certainty is referred in some of its recitals, and we think that the legislator actually has done what was possible regarding the design of the obligations imposed on gatekeepers. However, the cross-sectional application of the principle of legal predictability might actually be missing. With this in mind, and recalling the voices that qualify the digital markets as a beacon to the world or for the world, we will begin this presentation and we will try to summarize the DMA's aims and structure, and we will then address some doubts regarding its compatibility with legal certainty or predictability as a principle of the rule of law. And conclude by providing some thoughts, some facts for discussion or solution of an avoidable tension that Vinícius brought us here between the principle of predictability and the need for some flexibility, openness, and open textured rules and solutions in regards to the domain. Before that, I have here some questions that function as some food for thought for all of us. And maybe posed when speaking of legal predictability in digital markets. The first one is it possible to regulate digital markets through clear, specific, and common standards? The second is this a better solution? or should we opt for open provisions? The third one, it relates to something that I will speak of later, is if we can achieve a digital market regulation that does without a cooperative approach between all stakeholders, that does not function with active engagement, regulatory dialogue as a transversal or transsectoral principle. The last one is a provocation here, is the idea of self-execution or self-executing obligations forcible or just a nice to stay or act. All these questions reveal that the balance that Vinícius was speaking between legal predictability on the one hand and the desire to regulate and faster digital markets and avoid unfair behaviors is indeed a hard case for which radical approaches are not suitable. In our view, the solution for this hard case cannot depend solely on the legislator and the normative framework per se, but has to rely also, and perhaps above all, on the way that framework is enforced and executed by the administration that has to deal or cope with fundamental rights and principles and to adopt a participative approach, and as well, in the end, we think, on the review of that same execution by independent courts with full jurisdiction. Building on this, let us then proceed our informative part in order to quickly move to the core and conclusion. The DMA's focus lies, as we said, on contestability or openness on the one hand, fairness on the other, and also on some kind of users' autonomy. While recognizing that digital services in general and online platforms in particular are actually good and positive for the economy, the legislator seems worried about contestability, fairness of core platform services provided by gatekeepers. And the reason for anxiety in this respect lies in the risks that arise from the combination of economic power on the one hand and some features or special features of digital markets that we already know and can be summarized with the idea of winner takes all or winner takes most market. That concern and the wish to intervene before the market tips irreversibly, before it's too late, the DMA provides for a thorough set of harmonized rules of the prohibitions and positive obligations that are built in order to ensure that digital markets remain fair and competitive. In this respect, we have a structure divided in 6 chapters. I will not give you so much on this. I will just say that although there is no doubt as to the urgency and importance of a regulatory framework capable of avoiding some of the shortcomings of competition rules that Vinícius always also told us and fits for the digital age, the DMA and the simple idea of regulating digital markets through a list of ex-ante obligations on blacklist may raise concerns in terms of legal predictability. And well, as it is clear from the case law of the European Court of Justice, I have here just 2 examples. The principle of legal certainty is a general principle of EU law and the corollary of the rule of law, which is that situations and legal relationships governed by law remain foreseeable. While transversal to different policies and contexts, it directs itself towards a same objective, same core idea, to preserve certainty, stability, unity, and consistency of the legal order. However, despite this common core, the principle of legal certainty splits into different requirements according to reality and state. As to the design of normative acts, it requires, of course, that legal rules be clear and precise. But when applied to institutions, it implies another set of requests, the need to avoid inconsistency in the implementation of legal provisions, equivocal situations, the introduction of elements of uncertainty, as well as a lack of clarity in the applicable legislation and the way it is interpreted and applied by the enforcer. Finally, and the thing that is common to both plans, legal predictability also demands that sanctions for the breach of law can only be imposed if they follow from a clear and unambiguous legal basis. Of course, one cannot deny the need for a proper balance between legal certainty and the flexibility, speed, and equity demanded by enforcement in digital markets. This set of rules, the DMA, is a good example of the need for such balances and the advantage of a semi-flexible approach capable of ensuring both aims without annulling one of them. Of course, this semi-flexible approach is only called for those who consider the principle of legal predictability to be applicable also in digital markets. And this is not consensual. Indeed, there are voices who question the need or the possibility or feasibility for the DMA or any regulation on digital markets to be predictable. And this is so because we have the need of context-specific economic analysis, which takes account of a variety of business models and assortment of market players. But this same idea can actually give force to the voices that sustain the opposite approach. That is the approach that rejects a regulation which brings in more insecurity and therefore problems and advantages should be replaced, at least at the moment, by more flexible instruments such as soft law combined with regulatory dialogue. Dilemma relates with the two first questions that we have made. Is it possible to regulate digital markets through clear rules? Is it better to have clear rules, or should we opt for open texture provisions? But maybe these are indeed false questions, because quite similar to what is frequently said about competition law, predictable norms and case-by-case analysis are not mutually exclusive. And this is so because it's possible to achieve legal certainty not only through the legislation, not only through normative design or the letter of legal acts, it can be achieved through further densification by the enforcer and judicial powers. And that specification or determination cannot do as regards digital markets without active participation of markets players. In our view, only this cooperation may allow for that solution that, while forcing companies to respect fundamental values such as contestability and fairness, does not produce a chilling effect on innovation. There are many voices that criticize the relationship of the DMA with legal certainty, from the absence of a superior or current regulatory idea between the list of different obligations, to the fact that the do's and don'ts provided for in the regulation include obligations that may well call for further specification, for further clarification. Just to give an example, while some form of regulatory dialogue applies to the obligations provided for in Articles 6 and 7, it does not apply to obligations provided in Article 5. And we think that this is an example that shows how an important dimension of legal predictability may get jeopardized. That is the ability for the subjects to comprehend not only legal obligations, but also to determine specific actions in response to that obligation. Jeopardized because of the provisions later, not only because of the provisions later, but because of the lack of the densification and regulatory dialogue with companies. In sum, And to finish, our view is that ensuring legal certainty does not depend solely on the way rules and obligations are positivized. Of course, clear and precise rules are the preferable solution, but in circumstances like those of digital markets, being absolutely blind to individual circumstance and ignoring the particularities of context through one-size-fits-all solution is something that does not work and justifies departing from a formal approach and try to focus on the foundational idea of legal predictability, protect individuals from insecurity. And in this regard, we think that acknowledging that gatekeepers or accepting that gatekeepers are not necessarily the bad guys, we must consider that any preventive, corrective approach like the DMA cannot fail to obey to fundamental principles and protect not only the individual, but also the ends of the legislation. So all in all, legal certainty continues to apply, must apply, but in a different fashion, perhaps. And many thanks for your attention. I'm really sorry if I have missed the time.
Many thanks, Inês, for your great presentation, which indeed gave us so many subtopics and opportunities for discussion. So if for the moment there are no yet questions from the chat, of course, I will kind of take advantage of my position to raise a few questions, or better comments that I would love to hear your opinion, Inês and Vinícius, about, considering your very in-depth knowledge of the topic. Looks to me that sometimes, when we discuss about predictability of competition law, or even more of the enforcement of competition law, certainty for companies that very often are putting in place conducts that were not existing before, that maybe in the tech sector will become a standard, but before there was no decision about. It's something that is establishing a sort of divide between competition law from one side that should be applied ex post, and regulation that generally speaking is ex ante and kind of tailor shape the functioning of the market. And I do have 3-4 comments, and then maybe you can have some time to reply and to elaborate more on what you think is more important to discuss. The first comment I have is that maybe, as also the two of you were pointing to, there is an alternative, there is a mixed approach. And in this sense, I have two specific cases I would like to receive a comment from you. The first one is this UK approach. As you know, the UK approach is in the sense that one size does not fit all. So they decided to go in a way that is midway between competition law enforcement and the DMA, by targeting, by labeling those companies that have a strategic market status, SMS, and by negotiating with them an ad hoc code of conduct and leaving room for proving efficiency, so a big tech can still prove that there is an increase in the efficiency of the market, and so on and so forth. With this still system that, in my opinion, is establishing a way to define companies that is quite similar to the one using the DMA for gatekeepers, but the effects are completely different. So I would like to know your opinion on this alternative model. And of course, another alternative model that, as Vinícius mentioned, is my field of research with the Marie Curie Fellowship, is this idea of having a regulatory sandbox. What I mean is a regulation, of course, but as an experimental regulation that is made just to know how is better to proceed, and very often will go in the direction of the reduction of the regulation. So the question that I'm taking from this general comment is, can we say that DMA is too advanced in the sense of prohibiting conducts in a very, let's say, non-flexible way, and this is something that resulted from your presentation, while maybe a more flexible regulation, a more experimental way to proceed, similar to what the European Commission is doing, for example, while regulating artificial intelligence would be a better option. And the very last comment that is linked to this, and then maybe I will give you the floor and go back to other comments, is I don't know if you heard about this case we had in Italy against Amazon. So what happened is that recently, at the end of last year, the Italian Competition Authority imposed a very, very high fine to Amazon for abuse of dominance, of course, applying 102. And this is an investigation which is actually a copy of the investigation by the European Commission. What happened is that Amazon abused of the dominant position in the Italian market by giving advantage to those sellers that were also subscribing the logistics service offered by Amazon, okay? So if you were selling on Amazon and using the logistics services by Amazon, you were having, for example, the Prime badge, or you were having the buy box that is giving you more possibility for clicks, or you were invited in special offers and pillar events, so on and so forth. Interesting enough is a 100-page decision, very, very economic grounded. As Vinícius was saying, this is a way we can kind of increase somehow, but it's not sure that is always a way to increase certainty. And at the end of the day, what I noticed, I'm studying this case, is that the Italian Competition Authority is labeling this conduct in many different ways. So sometimes it's referring to tying, sometimes to refusal to deal, and then is using the buzzword self-preferencing. And I completely agree with Magali Eben, our colleague that is also part of IBCI, about this idea that this is somehow making even more difficult to understand the certainty. But in my opinion, we're in front of a very classic case of tying, because Amazon is asking you to use their logistics services to sell on, to receive platforms privileges. But the Italian Competition Authority is pointing towards self-preferencing, and is making a reasoning that, in my opinion, is overcomplicated and is also extremely difficult to rebut. So these are just very basic inputs for you, and then I would be grateful for your reaction on them.
Thanks. I don't know if I want to follow the order, but regarding Inês' presentation was very good, and one of the things that I want to listen more maybe is this process of densification. I think very interesting, because, and this is something that is in the comments, because I think have like two moments. You have a very disruptive innovation or a very changing reality, and it's hard to do one size fits all, to do a rule that's gonna, but I think the risk is that if you do like a per se prohibition, and you can do ad hoc changes like from time to self-preferencing, and maybe and you get away with that, like that's a moral hazard if you're gonna keep doing that. And you're gonna, if it's easy to punish, and you don't need to elaborate better this concept of self-preferencing, or you don't need to do a very predicability approach with a lot of predicability, or if it's economic grounded but has some kind of complicated twists, as Laura said, then why do we need to develop better the concept of self-preferencing if you can use like as a joker in your card? So I think the important thing maybe is not maybe can be not having legal certainty in the beginning now, but we're going to have legal certainty or legal predicability as a next step, as this is objective of the European Commission or Brazilian Competition Authority or similar entities, because the risk is that if you don't aim that in the beginning, maybe you don't need that, and this is gonna consolidate in a not so well balanced manner, I think. And Regarding the K approach, I think it's a very good approach. I think if you do an investigation, market investigation, or you try to do a things like said, and have room for discussion, you're learning, and maybe you're consolidating a better framework. And if in the next step you have incorporate that and use that to have more legal predictability, legal certainty, I think that's a good approach. And the question of the this, I think, very interesting, this regulatory sandbox, because it's the same thing. If you have experimental regulation, and this is gonna end sometime, sandbox is not forever, and you're gonna have a, I don't know if the word is good, but definite regulation is better standard, and this maybe is the time when you're going to have more legal predictability. So I understand it's fair to regulate during the beginning of digital markets, but you're aiming to change to have more legal predictability in some years from now, or in the near future. This is, I think, it's important. Thank you very much, Laura, for the comments.
Thank you. So I guess it's my turn now. So Laura, thank you so much for providing us with some food for thought. I will follow the three points you mentioned. As to the UK approach, absolutely in favor of not one size fits all solution. The problem of dealing with digital markets is that we are dealing with different business models. Different business models that only companies know, or that those companies know better than the Commission or national competition authorities. And my anxiety with this is that national competition authorities and Commission tend to impose their own view of how the business model should be, on how it should be structured, and they actually are not aware of the cost of what that has implied for the company, of how that actually operates, or if it's feasible at all when adopted by that company. So since companies are the most better positioned for that, I think that we must avoid over-regulation. We must avoid one-size-fits-all solution that may not make sense when applicable to all gatekeepers, to all providers of these core service platforms. Of course, this is more burdensome for the Commission, for the national competition authorities. That is a reality. But since we are dealing with fundamental rights, the freedom to conduct a business, to make their own choices, to organize their own company, I go back to my first question. We must ensure respect for fundamental rights. And the idea of this is too costly for us cannot overcome the fact that we are trying to apply blacklist obligations to companies that may not justify them to apply as they are, as this is the case of the Article 5, or may prove to be, or to have a chilling effect on innovation, because they say we won't be able to deal with this kind of obligations. We prefer not to innovate, not to offer the service. So this can have, we can have a problem here. And of course, I will be more in favor of one size does not fit all. Of course, you may say, but ensuring or generalizing concrete cases may be more friendly toward the principle of equality. But one must not forget that the principle of equality only demands to treat equally what is equal, and not to treat equally different situations. And we are dealing with different situations. So that is my take on the first point. As to the second point, absolutely in favor as well, because the regulatory sandbox are actually an example of that complementary mechanisms that I spoke that can help the law to achieve legal certainty that the text does not provide. And as I said, there is no problem with open text norms or provisions if they are supplemented by mechanisms that ensure that companies do what they must know, what they must do or mustn't do or should not do. So I think it's actually one great example that was also or that has also been being applied in the financial sector, and the modifications that the digitalization has also impacts on the financial sector, like fintechs, are also in national regulatory approaches being used as an instrument to provide companies with legal certainty as regards the regulatory framework that is applicable to fintechs and blockchains and etc. So I think it's a solution that is already being applied and that proves itself to be quite advantageous. As to the third point, I will just say that, as I said in my presentation, while having a common core, the legal certainty also applies to institutions' behavior. And one of that demands is that administration and the executive has to be faithful to their past conduct with some sort of res judicata applied to the administration, and must always justify if it departs from previous approach, from a previous understanding. This is the case when we are speaking of a historical approach. In the same decision, that is even stranger because that is really bad. And mixing, in my view, mixing different theories of damage is a proof of or how should I put it? Is a proof of the need not to prove the case against the company. Is a proof of the need that doubt must not be solved against the company, because this is against the principle of in dubio pro reo. And I think that is an error of law, absolutely an error of law, to make different approaches, to not to reach a clear conclusion as regards the damage and the illicit behavior is simply to decide against the company. So these are my 3 takes on this.
So many thanks. I was checking if we have, yeah, I think yeah. So I don't know if there is any question from the audience, or if the 2 of you have questions or sub-comments. I mean, what I think, just to, because of course it's not easy to understand how the UK model will actually work. I think the comment you made about the possibility of authorities that at the end of the day decide about conducts and then find a way to make it sure that these conducts are actually not happening can work perfectly also in the UK model. So I really like the idea, I really like the approach, but I see similar risks that we're facing, in particular when we discuss, about predictability and certainty. Somehow maybe there are even higher risks, because this idea that there is an ad hoc negotiation of a code of conduct is making all the process less transparent somehow. So maybe I would like to make you to raise a question that is highly provocative. So as competition law scholars, should we hate DMA? Is it actually going against the spirit and the rationale of competition law? Because I mean, the 2 of you in particular in Inês' presentation, you systematize the rationale very well. So you find a way to, but I remember 2-3 years ago that during ASCOLA conference, everyone was shouting against the DMA because this is actually kind of shifting the paradigm and kind of depaupering, removing many possibilities for competition law authorities, because, you know, we have a list of conducts that cannot be carried out just because you're a gatekeeper, and that somehow remove the case-by-case analysis. So, I mean, just if you can give me a quick answer to this provocative question, should we try to make the DMA fail and go back to ex-post application of competition law enforcement? Otherwise, what was the reason for this Google shopping decision that took so long and in the end found a place in a specific provision, in a specific regulation that is no more competition law enforcement?
Like that is because DMA is a very complex piece of legislation, but I think if as a competition scholars, it's more easy to hate or to love this ex-ante approach. I think to hate is like the bigger part, because but I don't believe, I don't know, I have less knowledge of European Union, but I don't believe that if there is a efficient business model, efficient conduct of a firm, and there is like not in the DMA application, but in some other jurisdiction, or maybe in UK or maybe in the United States, and it's like a consensus that's efficient. I think it's very hard to keep the ex-ante prohibition. Maybe on ground of fairness, but not. And then I think, at least my point of view, it's gonna be hard to say that we are doing competition law enforcement in this traditional way of viewing, but I don't know. It's easier to the most part. I can say that I dislike more the ex-ante prohibition than I like, but I understand that if you have this prohibition, you have more legal predictability. But I think it's better to have exposed and assessment with legal predictability. I think that's the ideal scenario for me.
So it's my turn. I don't have a quick answer for this. I nor love nor hate. I'm skeptical. Skeptical as regards its application, and above all, its articulation with Articles 101 and 102 of the treaty as regards competition law. I think that there has been here some idea of avant-gardism and the idea to innovate and to show that we are fighting big techs, that we are proving and we are adopting legislation that tackles behaviors that are unfair. But as I said in my presentation, one of the criticisms that is made to the DMA, and to which I adhere completely, is the idea of absence of a regulatory idea of a common core. We speak of openness, we speak of contestability, we speak of fairness, and we are dealing with rules that have a different nature from competition law. Maybe the path will not be something like a regulation that tries to achieve all these values, but maybe in each of these values and in each piece of legislation and normative acts that deal with specific values, maybe we should try to adapt the rules to the behavior of this, like we have seen in competition law. I also am quite skeptical to the normative technique of building on past competition law cases and build obligations while at the same time insisting on the idea this is not competition law. But the fact is that we are building on a competition law path, and perhaps that shows us that another solution would be possible, and maybe here the idea of presenting work a fast solution might have justified the adoption of a piece of legislation that is going to approximate the European Commission to some kind of FCT or FTC, and a big regulator, and providing it with powers that it didn't have before.
Yes, many thanks for your inputs and comments. I completely agree on that. And actually, that's something that resulted by both of your comments. Looks like that, yeah, regulations somehow increase certainty and predictability. From the other side, we're in front of a regulation that is very, very difficult to be enforced, and there are so many uncertainties. I mean, for example, there is a vibrant discussion on the authority that should actually, I'm thinking also about the, I mean, if we look at these regulations, so we do have the DSA for platforms, the DMA, the Data Act is far from being adopted, but still is increasing the obligations. And some of these obligations will interest the same company under the DSA and the DMA. And at the end of the day, it's very uncertain how this regulation will actually work, or even better, can we consider that they will be effective? How should we go in the direction, again, following the UK model of establishing in the member states an ad hoc digital markets unit? So the last comment, taking advantage of your in-depth knowledge in this field, is to try to figure out if you have some suggestions on how to contribute to make this overall resulting very complex regulatory scenario working well, because there are so many open questions, you know, about who should enforce it, how it should be enforced, how far the possibility to review and to add further obligations to go. So if you have your 5 cents on how to make this system actually work. Also because, and we close on this, I was recently in a conference with stakeholders, and I mean, we are academics who can say that among the lines they were arguing that they will boycott the DMA. They will make sure that this will not work. So as an academic, if you can give your answer on how to contribute in making it working well. So I don't know, Inês or Vinícius, you can go.
Sorry, no, okay. That's a very hard question. It's hard to answer, but I think like my if I had to say something, like the discussion of the institutional design of competition law is going to be more complex, I think, because this overlaps with data protection, AI law, and AI protection in different countries have one, two, or even the same entity responsible for enforcing. But my thoughts, like, it's hard to say that, in my point of view, it's the role of competition authorities to say the right business model of in digital markets, and you have to do some kind of have to judge cases, trying to build to find new concepts and adapt these concepts to institutional enforcement, to competition enforcement. So I think one big bet I'd make is that let's discuss more the economic and technical computer science aspects of platforms of digital markets, and discuss how this competition enforcement will do and try to densificate. I think the word that Inês used and the idea of her is very good. Densificate like concepts as mavericks, as disruptive innovation, competition enforcement, as the revival of potential competition or contestability. I think these are good paths. You can try to make these concepts more predictable. I think this is a bet I would make to make better competition enforcement. Thank you.
So to me, I'm with the companies, Laura. I think it's not workable at all. So I'm with them. I will just say that, first of all, the time framework that the Commission establishes for this type of rules are not feasible at all. I think there is overconfidence over the possibility of achieving practical results within the time framework that is established in the DMA. It's quite short, and I think lots of problems will be posed, maybe restored to courts, and lots of irregularities and problems as regards compatibility with fundamental rights. We have the Charter of Fundamental Rights that is also a piece of legislation that we cannot forget, and to which regulation must respect. As regards the problem of centralization, I think that the big problem is on resources. I don't think that the Commission is fit for having all this on its shoulders. I cannot say that national competition authorities support will actually make the difference. I think that the problem is actually with resources, and we must now include not only economists, not only legal scholars, not only people from the law and economics. We must have geeks, and we must have people that actually understand what we are talking about when speaking of these core service providers. And I don't think that that is the case for the moment being. And the clock is ticking, the time is already running, and well, I don't have so much confidence that this will have results in the meantime, practical at least.
Yeah. Honestly, I kind of agree with you. I mean, we're so far from, and of course we will have, as usual, countries moving at different speeds when it comes to establishing actually the authority that can help the existing ones to enforce. So we will see. We will have for sure differences in the overall system, but I'm not sure this will be the game changer, we all discuss about. So many thanks for the excellent inputs and comments. I mean, this was kind of a unique opportunity for me to discuss about these very interesting and dynamic topics. Of course, so many are the challenges that the predictability, the certainty of competition law enforcement is facing, also due to digital markets, but we can envisage many other possibilities. And I also like the idea of finding many clashes, okay, with, as Inês was mentioning, with the fundamental rights, or also with other values that should still be safeguarded and granted. So I don't know if the two speakers have something else they would like to share or add.
No, I'd just like to thank Laura, Vinícius, and all the people that followed us through this discussion. And my email is on the PowerPoint. I thought you can share them with me.
That's great. So many thanks, Inês and Vinícius, for this excellent discussion, and to IBCI for organizing such an interesting event. So I don't know if Vinícius, do you want to close this or say something?
Okay. Oh, it can be like, thank you very much, Laura. And it's a pleasure for IBCI to have this panel. And for me to present here was very nice, and I learned a lot from Inês, from Laura's comments. And we're in this panel, and invite everyone to see the next panel about private resolution of disputes. It's going to be in Portuguese, and it's going to start in 15 minutes. So thank you very much for everyone, and thanks.
Many thanks, everyone. Thank you.
Thank you.
Bye-bye. See you soon.
Bye. See you.
Bye.